Telecommunications, Interception Capability and Security Bill, committee stage continued.
I declare the House in committee for further consideration of the Telecommunications, Interception Capability and Security Bill. Mr Chairman.
Mr Speaker.
Mr Chairman.
Thank you. Good afternoon, honourable members. Kia ora tātou no reira, te whare, inga iwi, inga rio, inga hawe wha, tēnā koutou, tēnā tātou katoa, Mr Brownlee. Honourable members, the House... The House is in committee for further consideration of the Telecommunications, Interception Capability and Security Bill. And when we last considered the bill, we were debating clauses 1 and 2. The Honourable Member M. McKelvey had the call and has 3 minutes 53 seconds remaining if he so wishes to take the call. I call the Honourable Member Claire Curran.
I apologise for doing this. You mightn't have seen the member. He's behind a member who's standing up.
That's not a point of order. I call the Honourable Member Claire Curran.
Mr Chair. Mr Chair, we come to the part of this bill which gets down to the real nuts and bolts of what the serious problems are with this piece of legislation. We've had a long-running debate in this House. Well, certainly on this side of the House, right across this side of the House, that side of the House has barely contributed to the debate on this extremely important piece of legislation. But now we get to the part of the bill, the title and commencement clause, where we really consider what the serious issues are with this piece of legislation. And, Mr Chair, Labor has two amendments to this part of the bill. One of those amendments concerns the rights of New Zealanders and the Bill of Rights vetting process of legislation, which we contend, with regard particularly to this bill, has been very flawed and very cursory. And I do ask the Minister in the chair and also the relevant minister associated with the Bill of Rights vetting process to pay particular interest to this part of the discussion on this bill. Mr Chair, I want to return us to the Human Rights Commission and what the Commission said around both the GCSB bill and the TICS bill, as it's called in this House, the Telecommunications, Interception, Capability and Security Bill, which we're discussing today. The Commission said in its extraordinary report to the Prime Minister that it considered that what was proposed by both the GCSB bill and the TICS bill was too wide-reaching. It did not provide adequate oversight and made inadequate provision for ensuring appropriate transparency and accountability of those who administer the legislation. It does not provide for a legal regime containing sufficient safeguards against abuse of power and to facilitate a proportional approach. The Commission said that it recognises that some level of surveillance is inevitable and can be justified in contemporary democratic society. Labor would agree with that statement, absolutely. There is no doubt, and there has been ever any contention during the debate on this bill that there is not a need for legislation for oversight in surveillance in a democratic society. But it's a question of balance, and it's a question of tipping the balance, which is what this legislation does and what the Human Rights Commission, which is what that minister should be taking account of, it's what the Human Rights Commission has warned in a very serious warning to the Prime Minister and to this Parliament about the implications of that, and we should all be taking account of that. The Commission went on to say that there was nothing to suggest that surveillance in a democratic society such as New Zealand cannot be subject to human rights principles and consistent with an approach that protects human rights by limiting rights in a manner which is proportionate and justified in accordance with the law. This legislation before us today does not do that. Mr. Chair, Internet New Zealand's submission called for this bill to undergo a thorough test of this bill, the TICS bill, against the New Zealand Bill of Rights Act. The New Zealand Law Society, in its submission on the GCSB bill, called for the same.
Point of order, the Honourable Jerry Brownlee.
Mr. Speaker, this is supposed to be a very tight debate on schedules, title, etc. That speech is certainly straying very wide of that. I appreciate that the Chair is the only judge of relevance, but that does not prevent anywhere in standing orders any member raising the issue of relevance with the Chair.
Point of order. Speaking to the point of order, Mr. Chair.
Speaking to the point of order.
Thank you, Mr. Chair. If that member had been listening to the debate, he would have known that I was referring to one of the amendments that Labor has put up on this part of the bill, the title and commencement clause, which is about the Bill of Rights.
I can't find it now, but can I just remind members that there was a review of the standing orders, I think it was 2008 or 2011, where what actually happened, we said that this particular clause would be wide-ranging, and that's in fact, I can't find it, but I know that it's there. I can call the honourable member Claire Curran.
Thank you, Mr. Chair. Thank you. I'll continue where I left off, and perhaps the member could pay more attention.
There won't be any loss to the House.
There won't be any loss. As the submissions by Internet New Zealand and the Law Society and the Human Rights Commission have all said that these bills fail to provide adequate safeguards for people's privacy, to balance the intrusive power of the state to collect the private information of New Zealanders. We also contend that it's not, Mr. Chair.
The Honourable Member Claire Curran.
Thank you, Mr. Chair. We also contend that this issue, particularly with this bill, is curtailing the rights of private companies and their abilities to protect their information because of the lack of adequate checks and balances. So, Mr. Chair, we reiterate that this bill did not receive more than a cursory vetting, a once-over lightly in its examination under the New Zealand Bill of Rights Act. We don't believe that that was taken seriously. Secondly, we believe that the bill as amended, as it has been substantially changed in many cases in ways that are untested, where the impact of those changes on the rights of New Zealand citizens and businesses to privacy are under question. Therefore, Mr. Chair, we have put an amendment in this part of the bill that this bill may only be submitted for royal assent if a select committee has reconsidered it and reported that the bill is consistent with the New Zealand Bill of Rights Act 1990. And if the member over there actually has an issue with this, then I invite him to get to his feet and take a call and tell this Parliament why there should not be another vetting under the New Zealand Bill of Rights Act, and whether or not there has been a thorough vetting in the first place of the original bill. That would be a useful contribution for the Attorney-General to make to this House, because, Mr. Chair, not only this bill, but we have seen a consistent pattern of rubber stamping of the New Zealand Bill of Rights Act. At the beginning of the term of the previous term of this Parliament, there was an indication by the Attorney-General that he would take seriously that process, which is an extremely important part of our democratic process. For a few bills it seemed that this was the case, but now that's all gone out the window. It's all cursory vetting, rubber stamping, and unfortunately not taking account of what organisations, august organisations such as the Human Rights Commission, the New Zealand Law Society and Internet New Zealand have said in the Select Committee on this process, and have certainly said publicly. We contend that there should be a rights-based approach. Whenever there is a piece of legislation that deals with surveillance and deals with curtailing rights, there should be a corresponding rights-based approach. And it certainly does appear that there is a gap in our law around the rights of New Zealanders and New Zealand businesses in the digital environment. And we think that that is worth taking seriously. The Human Rights Commission certainly believes that it's worth taking seriously. They say, in the case of the TICS bill, the rights of concern in relation to the proposed legislation were the right to freedom of expression, the right to be free from unreasonable search and seizure, and the right to natural justice. The analysis, the cursory analysis, concluded that all of that could be justified. The Commission does not agree with that conclusion, and neither does the Labour Party agree with that conclusion. Mr. Chair, we believe that there should be a rights-based approach, and that there should be, and as I have repeated a number of times during the debate on this bill, that along with surveillance should be a rights-based approach to New Zealand's privacy. This is absolutely critical to a functioning and healthy democracy. This should include the freedom of expression of thought and freedom of thought, conscience and religion, freedom of peaceful assembly, freedom of association, freedom to determine whom a person shares information with and to terminate involvement with a provider, unreasonable search and seizure, where everyone has the right to be secure against unreasonable search and seizure, whether of the person, property or correspondence. For example, emails, the right to privacy based on the principles of the Privacy Act, a comprehensive set of principles on the collection and use of private information.
Honourable Member Grant Robertson.